Clerk, please call the first case.
Morgan et al. Versus Board of Supervisors of Hanover County et al. Brian L. Beneva, Appellants Counsel. Dennis A. Walter, County Attorney. Robert W. Lofton, Appellees Counsel.
May it please the Court. My name is Brian Beneva. I'm honored to be here this morning, and I'm particularly honored to represent my clients, who I've nominated as the homeowners in the briefs that have been filed. This case is actually a very simple case, which is surprising when you look at the volume of paper that's been generated, both in the joint appendix and in the various briefs that have been filed. And the reason that has happened is because I think people have lost sight of what this case is about and have introduced a whole bunch of information about what this case is not about. This case is about standing. What we do is we look at the pleadings, in this case an original bill of complaint and an amended bill of complaint, and we see if there are enough facts alleged and reasonable inferences that are drawn from those alleged facts to determine whether or not my clients have been particularized, have suffered a particularized injury or will suffer a particularized injury as a result of the construction of a 1.7 million square foot warehouse, distribution center, and trucking.
But let me ask you a question.
Yes, sir.
Does it have to be whether or not they suffered damage as a result of the construction, or is it they have to prove that they have suffered damages as a result of the zoning change?
We have alleged that they've suffered damage as a result of both. That without the zoning change, the construction would not have occurred, and that is going on right now, and in fact is creating incredible reduction in the quiet use and enjoyment of the surrounding properties, which are populated by my client.
May I ask a point of clarification?
Please.
With regard to both? It seems from the pleadings that the construction was approved in 1995 or thereabouts, the construction of the warehouse itself. It seems that more recently there have been proffer changes that affect perhaps three aspects of that construction. Would not your client's standing or any ability to challenge the 1995 action be too late?
Well, that's an interesting question raised for the first time in the appellate court, never raised below. But to answer that question, it is not the case. It is very clear from the record that the action taken in 1995 was what has been referred to as counsel for the defendant and the planning director as speculative zoning. They took agricultural property and changed it to light industrial. And in that, under the zoning ordinance, I think it's something like the order of 20 different uses are potentially there.
Which includes a distribution center, correct?
Which includes a warehouse, yes. That's right, and that's not in dispute. But it was not until this zoning action was filed in 2019 and ultimately approved in 2020 that we knew with any degree of specificity what would be generated in terms of actual traffic impacts, truck additions. We're talking about over 3,000 additional vehicles per day on 2-lane country roads on which, or very close to which, my clients reside. One of my clients lives literally across the street.
But you wouldn't have any claim at all concerning that other than the fact that the proffers were amended, right?
Right. When the proffers were amended, it included the concept plan, which detailed for the first time in 25 years exactly what was going to be there, and we could surmise exactly what kind of impacts, negative impacts, would be suffered by my clients. So yes, it does kick off with the 2019 application, 2020 vote. But just because a property is zoned speculatively and can have a whole variety of potential uses in it doesn't necessarily create an injury. In fact, I dare say if suit had been filed in 1995, would have said, well, you know, you don't even know what's going there. You know what's potentially there, but you don't have a particularized harm. Today we do.
Does the timing actually go to the standing question at all? Traditionally, standing is who has a right to sue, not when do they have a right to sue.
That's exactly right. That's exactly right, Your Honor.
But what about what they're suing for is really the question here.
What we're suing for is we've brought a number of counts that essentially allege that the Board of Supervisors, in the process of approving this zoning, committed errors of law, violated their own ordinance, their noise ordinance, for example.
I'm going to stop you right there.
Yes,
but
sir.
That's concerning the 2020 rezoning.
That's right.
Okay.
That's right. Yeah, everything I'm about to say relates to 2020. And by the way, I forgot to ask, and I hope it's not too late, but I'd like to reserve 5 minutes of my time for potential rebuttal.
You got 9, so you can do it.
Thank you, sir. So take a look at the cases that this court has decided in the last, actually in the last 6 months, but even before that. And what we have here is allegations that my clients will be harmed by the noise of the operation, by the lights, the extension of the light poles, almost double the size as a result of the actions currently taken, by the number of trucks on roads that will or are already, I mean, if you've ever driven up that way, we're talking about 2 narrow country roads, Sliding Hill Road and Ashcake Road, and they're very, very tiny. My clients, the Woodcocks and Millers, they live directly across where 700 employees in 3 shifts will come in 24 hours a day, 7 days a week, 365 days a year without any respite. There are industrial properties near here, and I drove up there on Sunday after church, and what did I see? They were all closed. This operation will never close. So this din, this traffic congestion, this noise, this at nighttime light will always be there. And if these folks don't have the right to come into the court and seek justice, who does? If this court decides that these clients do not have the right and have not pled properly the injury that they will suffer as a result of the actions taken, and now because of the concept plan, we know exactly what's going to go on there, then nobody but people who own the property will have the right to challenge the zoning. That's really the logical extension of this. This is a very important case, and we cannot allow the courthouse door to be shut. We're all about access to justice. This is the quintessential access to justice case of my career. There are residences all around this area, and then there's light industrial action as well. But we have a building here that has the footprint of the Pentagon, snuggled in between a historically black community, my clients on one, literally across the street, across from the employee entrance, and the others within, I think it's 1,000 feet of Sliding Hill Road. They certainly have a right to determine whether or not, to ask the court to determine whether or not, in exercising its zoning power, the Board of Supervisors followed the law. And that's what we're asking the right to do. I just can't think of anything else to say, which is why I'm reserving 5 minutes.
A hopefully quick question.
Yes, sir.
I get the idea of light pollution and truck traffic and so on. One of the allegations deals with the type of materials used at the front of this, some sort of aesthetic injury. That seems awfully amorphous to me. Can you help me figure out why that has anything to do with standing?
Well,
someone dislikes the appearance of something?
Well, I understand. It just is one of the things that was changed, one of the proffers that was changed from 1995 to 2020. But in fact, it does. Listen, if my case was just that, I don't think I'd be here. That is an injury, but is it the grossest injury you'll ever suffer? No. But what it has to do with is the ability to see the structure and what it's going to look at. I remember gosh, I forget which case it was.
5 minutes.
Yeah, I don't need to take up too much of
That's all
your
right.
time.
I think this is an important one to take a little bit of time on.
Sure.
Thank you for the reminder, Your Honor. There was one case that I read, gosh, I've read so many now, and I can't remember the name of it, but it had to do with the condition changing it from metal, I think it was the Seymour case, changing it from metal to structure to wood, because that would be more aesthetically pleasing as the presumption. So, at any rate, without any additional questions, I will reserve the balance of my time. I do want to say one thing. Do not be confused by, not that I think you will be, but I have to say this, do not be confused by the effort to load up this record with things that are outside the pleadings. There are 619 documents that were proffered and never considered on a motion craving order. No assignment of error was ever assigned to that, and frankly, they should not be even heard before this court on that point. Thank you.
Yeah.
May it please the court, good morning. My name is Dennis Walter. I am the Hanover County Attorney, and I'm here today on behalf of the Board of Supervisors. Robert Lofton, who's counsel for Wegmans, and I are dividing our time, and we'll focus on different aspects of this appeal. I'll largely be addressing the procedural claims that were raised by the homeowners in counts 1 through 4 of the complaint and the amended complaint, and also those that are in counts 6 and 7 of the complaint. 6 and 7 is the Chesapeake Bay Preservation Act. Count 7 is the noise ordinance violation. Mr. Lofton will be addressing the larger issue of standing, as well as the counts 5 and 8 of the complaint. The two assignments of errors, as Mr. Beneva pointed out, are limited to the trial court's determination that the homeowners lack standing as to the entire complaint and the amended complaint, as well as the allegations in counts 6 through 8 of the complaint are speculative and do not provide justiciable claims. The trial court was correct in those findings, and the reason why I address the procedural claims is that the homeowners maintain that their harm is premised upon violations by the Board of Supervisors in conducting the public hearing in May of 2020. With regard to count 1, the homeowners allege violations of Executive Orders 53 and 55. However, the pleadings show that the homeowners completely either misunderstand or misrepresent the contents of those executive orders.
But does that go to whether they have standing to bring the claim or whether they would ultimately prevail? I mean, might they have standing to lose?
I believe it goes to standing because they allege that is where their harm, the genesis of their harm is from, is the fact that the board improperly held that public hearing, that it violated the executive order. If the court
should we, sorry to interrupt, but why should we go to the merits of the case and decide in your favor and just jump right over the standing issue? The standing issue is simply the right to show up and say something. It's not winning or losing on the merits.
At this point, we're not asking to go to the merits. We're looking at the pleadings as were presented by the homeowners. The allegations that are contained in there include a purported harm because of the board's actions and whether they violated the executive orders.
Well, understood, but your argument seems to be we didn't violate the orders, but that's a merits response.
I don't ask you to take my word for it. I ask you to read the pleadings and to read the plain language of the executive orders, both of which are before the court.
I've got another question for you. It seems like to me they're saying their damages are not the failure to follow the procedures. They're saying the damages are the reduction in the value of their property, et cetera, and the action of the board is invalid because it failed to follow the procedures. So they're not necessarily saying that the procedures hurt them. It's the failure of the county to follow those procedures, which results in the particular rezoning being determined to be void ab initio.
I agree that a portion of the complaint and the amended complaint say that, but if you read counts 1, 2, and 3, the harm they allege is the fact that the board held the public hearing and under the procedures that it did. There is no, that is the sum total of those counts, that the harm
But
suffered.
Isn't it a reasonable inference that what the argument is, if the proper procedures have been followed, a different public hearing occurs, and whether this is right or wrong, it's a merits question, and a different result might have obtained? They may not be able to prove it, but that's a merits defense.
It may be, however, the pleadings themselves allege that harm. We're here because the trial court found that they do not have standing because...
Let me ask you this. I mean, what if that didn't cause any harm at all, but it was just illegal for the county to do what it did? What does that have to do with whether or not they're standing here?
Well, I think that there are two issues to that. One of which is if it is a purported violation of the open meetings provision of the Freedom of Information Act, there's a separate procedure for doing that. The second issue, I agree. If in fact the board is violating the open meeting provisions, that goes to the merits of a decision, whether or not that is void ab initio or not. The challenge for the homeowners here is that they allege that, and then in the same complaint allege that they attended, 3 of the 5 of them attended the public hearing, that the public had notice of that public hearing, that the public was able to attend the public hearing, that it was live streamed. So I just ask that you look at the complaint because on one hand they say there are all these violations, and on the other hand they say...
The way you get standing is not to allege violations. The way you get standing, that's the way you win a case, is to allege violations and prove it. The way you get into the courtroom is to allege some harm. And they allege quite a lot of harm. Increased traffic, tractor-trailer traffic, increased noise, decreased property value, decreased quiet use and enjoyment of their property, increased flooding, increased traffic accident. So those have nothing to do with the underlying cause of action. They're simply consequences if they lose the underlying cause of action. So I'm struggling greatly to understand conceptually how you framed the standing issue.
The standing issue, I agree, it deals with whether or not there is harm. And Mr. Lofton will address a little bit more. I think what the substance, really count 5 is the substance of their allegations. There are 8 counts here, however. And in their briefs, they continue to argue that they suffered harm through all of those.
This may be a question better directed to Mr. Lofton, given the way you divvy up the argument, but I'm counting on you to have a better grasp of Hanover geography than Mr. Lofton.
Yes.
And that is, the person directly across the street from this development is going to feel whatever negative externalities there are from it more than somebody who lives in Ashland or Mechanicsville, so more than the average Hanover citizen, correct?
That is correct. However, I would point out that this court has articulated in Friends of the Rappahannock a 2-prong test, and that goes to the first part of this test. So certainly we have conceded throughout the course of these proceedings that the individuals who clearly live across the street meet that first prong. The crux of this is whether they meet that second prong. Someone who lives across the street may not have a particularized harm. I see my time is up. May I continue?
Well, you almost run out of your time, but go ahead. I'll give you.
So certainly an individual who lives directly across the street may have a particularized harm. Their neighbor may not. And then the neighbor next door to them may. So there's the proximity part as well as the need for the plaintiffs in their pleadings to identify that particularized harm.
Thank you, counsel. Your time is up.
Mr. Chief Justice, and may it please the court, good morning. My name is Robert Lofton from McGuire Woods on behalf of Wegmans. We join in the arguments advanced by Hanover County. And as Mr. Walter said, I'm going to be addressing broadly the issue of standing. I'd like to start with the access to justice point because I think it's important for the court to remember that there are two proceedings that the appellants have initiated. Four of the appellants, there are five appellants now before the court. Four of them were also parties in litigation that was brought in Richmond that sought an injunction or a stay, depending on how you want to parse out the word. And Judge Marchant denied that request. That was appealed to the Court of Appeals. The Court of Appeals affirmed that ruling, and there was no further litigation brought up to this court. So they attempted to stop the construction in a separate proceeding, and that the proceeding was denied. They also filed this litigation, which is now before us. And I think it's important to remember that these folks, in terms of the access to justice point, they were able to participate in the public meetings. They were able to initiate litigation in Richmond. They were able to litigation in Hanover, and they had appeals to the Court of Appeals and now here.
I'm struggling to understand, though, Mr. Lofton, how any of that is relevant legally to the question of whether or not a prima facie showing in a complaint has established standing in an attack against a zoning decision.
So to the standing question, first, I think it's important to remember, one, proximity is not enough. So Justice Russell, to the question that you asked Mr. Walter, just because the Woodcocks and Millers, they are the ones that live across the street, just because they live across the street doesn't mean they have standing to bring a claim. And if you look at this court...
But it puts them in a different position than a lot of other people and makes it a better claim, doesn't it?
It puts the... No, sir. I would not agree that it makes it a better claim. I would agree that they've satisfied the first prong of proximity, which we have not contested that at all. So then the second question is, have they alleged a particularized harm? And if you look at this court's precedent from Seymour to Anders Larson Trust, back to Friends, back to Virginia Beautification, back to Nicholas in 1933, and Nicholas is the case that I think lays the foundation for the standing analysis. It's important to remember in Nicholas, the court said that the plaintiff has to allege a harm that is peculiar to them.
They've alleged peculiar increased traffic, peculiar increased noise, peculiar decreased property value, peculiar increased flooding, peculiar increased traffic accidents. So their theory is that if they lose the case on the merits, all these things will happen to them, which is really the only question, and correct me if I'm wrong, that we should be asking ourselves.
I do think that is the only question, is as a matter of law, have they alleged facts sufficient to state a cause of action? And
Actually, maybe I misspoke. I don't think that's the way I look at it. I think whether they allege a cause of action or not, whether you can win on a motion to strike, whether you can win on a demurrer or plea and bar, I don't see any of that as the issue. The first issue, as I understand the law, is they're saying I should be in court because if I lose this case on the merits, and we're not talking about the merits yet, I'm going to have specific harm that's unique to me, not to the public at large. I just want to get into court and argue on the merits. But if I lose, there's going to be some harm that I'm going to suffer, and it's going to be unique to me, or at least particularized to me. So am I understanding standing? I mean, it's a basic concept. Am I misunderstanding the idea?
Well, I guess I would slightly disagree, Justice Kelsey, because I think they have to allege facts which, if taken as true, show that they will be harmed. And this, if you look at this court's case law, in terms of the facts that it considers, sometimes this court has said you consider the facts that are expressly pled, well pleaded, properly pleaded. In Friends, this court said the facts have to be alleged with sufficient definiteness. And Justice Kelsey, your opinion in AH versus Church of God in Christ talked about the sufficient definiteness requirement.
But are they facts going to the merits of the individual elements of the cause of action, or are they facts going to whether or not there is some harm if they lose on the merits that's unique to them?
This court has made clear at the demur stage, we don't consider the merits of the allegations, and I don't think that's what Judge Harris did. If you look at his letter opinions, he assumed these facts were true. And he said, assuming that these facts are true, are they sufficient to state a claim, to state the claims brought by the plaintiffs, for them to have a harm such that they may proceed in court. And I think that's the analysis the court should engage in. And I think if you look...
Has he answered your question, Justice
Yes,
Counsel?
thank you.
Yes,
Mr.
ma'am.
Lofton, you make arguments in your pleadings differentiating what was allowed in 1995 versus what is allowed in 2020.
Yes, ma'am.
Help me to understand why that informs the standing analysis.
Well, I think it informs the standing analysis, and I think it's very important because if you look at the court's opinion in Friends, the focus needs to be on what were the acts of the Board of Supervisors that are the causal link for the harm. So the 3 alleged harms in count 5 of the complaint are the changes in building height, the changes in light pole height, and the changes in building exterior materials. And so there's nothing from the rezoning that happened in 1995 that should be allowed to be the basis of standing. And if the court is going to say that, I think it needs to make that very clear because that's going to be a sea change in land use law.
Acknowledging that some of the cases talk about timing regarding land use only, isn't that anomalous for our traditional understanding of standing? If I got rear-ended on Broad Street in 1995, everybody would agree that my claim is time-barred if I bring it tomorrow, but nobody would say that my claim is meritless because I don't have standing to bring it. It's just I'm going to lose. I have standing to lose because it's time-barred.
Well, I would disagree, Justice Russell, because if there has to be a causal link.
If I get rear-ended on the street, even if I blow the statute of limitations, I don't have standing to file the lawsuit, even if I'm the person injured in the automobile accident?
Well, in the context of a tort case, yes. I would agree there. But in the context of a land use case, this court has never extended a statute of limitations to go back decades to say, and so I think what the court...
I guess my point is, isn't that a merits defense, though? It's time-barred, but it's time-barred on the merits. It's not time-barred as to who brings the lawsuit.
Well, and can I just interject here? Because it seems like to me what Justice Russell is saying isn't the fact of whether or not there's a causal connection between the particular zoning violations and the damage a merits question. Well, they can assert whatever they want to say. They can say, "Oh yeah, we think that all these horrible things happened as a result of, the zoning change in 2020," when it's obvious that it didn't. But that doesn't. They don't lose standing. They have the standing to say that. The question is, is it meritorious?
May I respond to your question, sir?
Sure, please do.
So I think it's important because it goes to. So yes, there is a statute of limitations aspect to that. The reason we address that in our briefs is because of Mr. Beniva's reliance on Riverview below. Because central to Riverview and central to this court's decision in Riverview, where it affirmed in part and reversed in part the sustaining of a demur, was the fact that the zoning did not comply with the comprehensive plan. And so we wanted to paint a picture so that the court understood that the zoning decisions that were being challenged here go back to 1995, and some of them go back even longer. And so for the standing analysis, the court, Justice Powell, to answer your question, I think the court should look at the acts of the Board of Supervisors on May 6, 2020, and whether those acts, as alleged in Count 5 and elsewhere in the complaint, caused a harm to the plaintiffs. And I think if you look at Seymour and Anders Larson Trust, the harms alleged there were unique to the landowners, whereas the harms here and the harms in Friends, were generalized speculative harms. And so we would ask for the judgment of the circuit court to be affirmed.
May I ask one final question, hopefully? Opposing counsel pointed out that there are certain things in the record we shouldn't look at, the way the motion craving order unfolded, et cetera. Can you just briefly address that?
Certainly, Justice McCullough. I think we cited Primov, and we think, one, the court can only look at the initial complaint and the amended complaint, and I think if it does so and looks at the opinions from Judge Harris, Judge Harris was correct, and they did not allege a particularized harm sufficient to have standing. The court, we think under Primov, the court can look at anything else in the record, As an appellee, we're allowed to raise any other argument that was presented, that is presented in the record in support of what Judge Harris did. And to the extent you disagree with that, we think, especially the 1995 proffers, the 2020 proffers, and all of the board minutes and the official acts of the board, this court can take judicial notice of. So I think under Primov, I think everything that's part of the record, this court can look at. And to the extent the court wants to disagree, to the extent the court disagrees with that, you certainly can take judicial notice of the official acts of the Board of Supervisors.
Thank you,
Thank you.
Counsel. You have 3 minutes and 44 seconds.
Thank you very much.
Mr. Beneva, I'm still a little stuck on whether the harm, if there is harm caused by the 1995 action, may or may not be particularized to your clients as opposed to the change in the proffers for 2020. And I guess as a practical matter, I'm feeling that that both sides sort of make that argument, and I'm wondering if there is no difference, if the harm from 1995 is also particularized, why does paragraph 5 seem to articulate harm from 3 instances or 3 factors from the 2020 proffers? I'm just trying to figure out why I'm having difficulty grasping this argument.
If I understand your question, and I'll try to answer it, and if I don't, please ask it again. But it seems to me that what this court has it exactly right in terms of what standing allows you to do. It doesn't get you to the merits of the case. It gives you the right or the opportunity to prove your case. The case and the harm that has happened became real, if you will, under the 2020 action of the Board of Supervisors.
Not just with the 3 things alleged in paragraph 5, but with regard to all of the trucking.
Exactly right. Because, I mean, the county and Wegmans themselves have said that that this zoning gave us the right to do, this property could have 19 different uses on it, some of which might not have any impact on the neighbors and some of which might. But this particular one, particularly the concept plan, which is attached as Exhibit 1 to the Bill of Complaint and the amended Bill of Complaint, shows you exactly where the buildings are going to be, their proximity to people, the number of employees that are going to come in on a daily basis every day of the year, and so on.
Honestly, I kind of don't see how that triggers a new cause of action. It's kind of like saying I was hurt before, I just didn't know it.
It's not a new cause of action, I don't believe. It is new harm. It is a specific, particularized harm.
Is it new harm, or is it harm that always existed?
No.
By virtue of the rezoning to the
it is a new. You can have a warehouse, and you don't have 700 employees coming in every day. You don't have almost 800 tractor trailer trips per day coming in. You don't have another 3,000 cars coming in every day or going by and using these roads, impacting the neighborhood. Those are specific harms as a result of this rezoning action and the specific use that the county has allowed them to have. They say they could do it by right anyway. Well, then why did they go through all this if they could do it by right? Obviously, they couldn't.
Well, they wouldn't have the proffers that they have now.
Right.
It'd be under the old proffers. They could have done exactly the
That's
same.
exactly right. Now, I just want to say one more thing. What this case on the merits is about is whether or not the Board of Supervisors followed the law in taking the action that it did. Our allegations are that they did not, and that therefore the action is void ab initio.
Thank you.
Thank you very much.
Take care. Please call the next case.